Good afternoon, everyone. If we could have folks take your seats. There's a bunch of seats in the front. I know no one wants to sit in the front, but I can assure you no one's going to get called on. So here we go. Here's Mr. Singer is going to come down and be in the front row. Everyone, welcome once again. Those of you who are here for the State Bar of Montana's annual meeting, our 50th anniversary this year of the State Bar of Montana. Welcome again. My name is John Mudd. I'm the Executive Director and General Counsel for the State Bar of Montana. Those of you who are joining us from the general public or from the law school, we welcome you. Every year we do programming throughout the year for our members as part of their continuing education. But one of the missions of the State Bar is to also improve relations of the bar to the public. And so we decided as part of our 50th anniversary that we would open some of our CLE sessions, continuing legal education sessions, to the general public to observe. That includes sessions this afternoon, as well as the Montana Supreme Court's oral argument, which will be tomorrow morning in this theater. We also did another unique thing this year, and that's we partnered with the Montana Law Review and their Browning Symposium for this year, which is a symposium I believe they put on every other year for the Law Review on a topic of importance. And this year's session is on housing. And we've partnered with our friends at the Mansfield Center as part of their Community Dialogue series for our second program here this afternoon. Our final program will be a candidate forum of the candidates who are seeking the Associate Justice and Chief Justice positions that are open on the Montana Supreme Court. But without further ado, I want to introduce a member of the Montana Law Review, a third-year law student, Colin Stetzner. He is going to introduce our speaker this afternoon, which is the keynote for the 2024 Browning Symposium. Colin.
Good afternoon and welcome to the 2024 Montana State Bar Conference, which features the Browning Symposium. As John just said, I'm Colin Stetzner and I'm the intake editor for the Montana Law Review. I want to thank some people before I begin my remarks. First, to John Mudd and the State Bar, thank you for allowing the Montana Law Review to partner with you and be a part of your conference. Next, to Dean Gagliardi and Assistant Dean Browdy for all their support throughout our planning. And to the Browning Symposium editors, Noah Gibson and Lauren Halverson, and the editors-in-chiefs of the Montana Law Review, Michaela Amon and Jessica Maynard, for all their work in planning this event. I would like to thank our sponsors next, beginning with our silver sponsors, Dreesen Law Group, Heenan and Cook, Tip, Coburn and Lockwood, McFarland, Malloy and Dirk, Paul Booth Smith, Laird Crowley, and Kaleva Law Office. And to our distinguished sponsors, Teal Law Office, Toe and Fitzpatrick, and Kutek Rock. And last but certainly not least, thank you to all our participants in the Browning Symposium. This year, the Browning Symposium is focused on a key issue facing many Western states, housing. Our symposium is dedicated not only to the introspection and deliberation, but also onto the crafting of pathways and practical solutions in the ever-evolving landscape of housing here in our great state of Montana. In recent years, we have witnessed an unprecedented tidal wave of challenges surrounding housing. From soaring prices that stretch the bounds of affordability to creative solutions that redefine urban living. Today, we find ourselves at a crossroads of change. Our mission this year with the symposium is not just to analyze these problems created by housing, but to cultivate practical solutions. With this mission in mind, it is my pleasure to introduce to you Howard Beledoff, this year's Browning Symposium keynote speaker. Howard began his career in 1978 at the Idaho Legal Aid Services after receiving a Reginald Herbert Smith Fellowship. Howard has been with Idaho Legal Services as its associate director since 1980. Howard also has a private practice which focuses on public interest cases, specializing in complex trial and appellate work. He has successfully argued 13 appeals in the Ninth Circuit, and his advocacy has established case precedents of national significance involving discrimination and constitutional rights under the First, Fourth, Eighth, and 14th Amendment, and the Fair Housing Act on behalf of unhoused persons, the LGBTQ community, including transgender discrimination and same-sex marriage, the privacy rights of persons with HIV, mentally ill children and adults, and Native American religious and trust land issues, inmates and prisoners, and statutory attorney fees. Howard was also the lead counsel in Martin v. City of Boise on behalf of unhoused persons. Howard is currently Idaho's District Court Lawyer Representative to the Ninth Circuit, and he received the 2021 State Bar of Idaho Distinguished Lawyer Award, the NLADA 2019 Reginald Herbert Smith Justice Award, the 2018 Trial Lawyers Association Trial of the Year Award, and has been recognized as a Mountain States super lawyer since 2010. Beyond his professional prowess, Howard is also a mentor and a beacon of inspiration, a person who encourages others to envision potential for positive change in their community. His tireless dedication to public interest should inspire us all. Without further ado, please welcome to the stage, Mr. Howard Beladoff.
Thank you, Colin. Hopefully you can hear me. I think the smoke has gotten to me before I got here. It's been pretty bad all over. Well, I usually start with may it please the court, but I guess I don't have to do that today. But I really appreciate the opportunity to speak to the students and members of the Montana State Bar. So it's kind of unusual that I think I was invited, because the Martin case, which I'm going to talk about, was overruled last June by the U.S. Supreme Court. But I don't think that the impact and the effect of that decision really takes away the overall progress that I think the Martin case brought to the issues which I'm going to talk about. Those legal issues faced by unhoused persons in everyone's community, and potential solutions to address homelessness without involving the courts or criminal punishments. So let me start by defining homelessness as I understand it. I usually start by asking questions. I also provide the answer. So, is poverty a crime? Is being disabled a crime? Is not having sufficient income to pay rent, is that a crime? Is sleeping a crime? Well, if you're homeless, the answer to every one of those questions is yes, it is a crime in many cities and localities in the United States. On a typical night, 580,000 Americans are homeless. Nearly 2.5 million children every year, that's 1 in 30, experience homelessness. People experiencing homelessness often lack reasonable alternatives to sleeping in public. They don't have a shelter, if they don't have a roof over their heads, they have to sleep. And the only alternative is not breaking into your home or a gymnasium or a theater. It's to find a place where they can lie down and rest or sit. Yet, cities have enacted these laws that criminalize unhoused people. So what is criminalization? Criminalization refers to laws that prohibit or severely restrict one's ability to engage in necessary life-sustaining activities in public, even when there are no reasonable alternatives. These laws, in my view, are intended to purge homeless individuals from public places. If you're not seen, We don't have to deal with you. But a homeless person, it can't avoid that. They can't go on private property because that's trespassing and a crime. And they have to be have a place to engage in human activities that we all engage in, and they can only do it in a public place. So criminalization, in my view, serves to perpetuate homelessness because persons with criminal records have a much harder time in finding housing and securing employment to pay for housing because they have criminal records. So there are many causes and myths to homelessness. Criminalization is fueled by fear, stereotypes, and discrimination. The causes of homelessness have nothing to do with voluntary choice. A person is no more, homeless person is no more likely to be a criminal than an unhoused person. All you have to do is read that in the newspaper or look at your crime statistics. Most of those people live in houses. Except one legal exception, sleeping ordinances. I call camping ordinance sleeping because of my definition of camping, which I'm sure everyone in this room camps. They're not camping. That's the only place they have to lie down and go to sleep and protect themselves from the weather. And criminalization disproportionately harms marginal communities, African Americans, Native Americans, people who are disabled physically, the mentally ill, domestic violence victims, veterans. They've suffered trauma in their service. I've seen all of this because, you know, I'm a regular visitor to shelters, not only to meet the clients, but to volunteer and to advise the shelter operators on certain things. A 2021 study from the University of Chicago estimated that 53% of people living in homeless shelters and 40% of the unsheltered population are employed full or part-time. And again, that's true. I've seen it. Yet they can't afford to rent an apartment, or they don't qualify for apartment, which I'm going to get into a little bit further. It's harder to obtain and maintain employment without a place to live, without a place to shower, without a place to keep your clothes, without a place to get your mail, without a place to get transportation to the job, to and from the job, especially in small towns when people work, the type of jobs that certain people have, the public transportation, such as it is, doesn't function at that time of day or that time of night. According to a 2022 U.S. Department of Urban Development report, 21% of the homeless people have severe mental illness. And that's a reflection of the failure of the system to provide mental health care in the United States. That's true in almost every state and every community. So what causes all this? Well, research has found there is a direct connection between homelessness and the lack of affordable housing. There is a shortage of affordable housing all over the country, and it's the single predictor of homelessness. If people can't afford to get a place to live and pay for the rest of, you know, their food, their medical care, just basic necessities, clothing, whatever, transportation, they're going to end up homeless. They're gonna end up in on the street, or they're gonna end up in a shelter, if there is a shelter that they qualify for, or they can get into, or there's a bed that's available. People who have disabilities, who can't work, they don't usually have too much income. And they cannot afford market rate rent. I don't know what the market rate is in Missoula, but I do know in Boise, it's much higher than what most people can afford of a low income or on a disability payment. In fact, SSI, Social Security Disability Income, is $914 a month. I don't know, can somebody pay rent on $914 a month and eat and do the other things that we all do? It's not possible. So they end up in shelters. People who have disability income end up in shelters, and they wait for, if their name comes up on a housing choice voucher list or some sort of local government housing program that they can qualify for and move in. And they can be there for years because there's no out. They just don't have an out. So in addition to all those things, there are just barriers to people getting housing. There's credit and background checks. There's security deposits and application fees. There's source of income discrimination. So I mentioned the Housing Choice Voucher Program, which is a federal program that subsidizes rent up to 30, based upon the person's income, between 30 and 40% of the income they have to pay, and then the voucher will cover the rest of the rental cost. But landlords can discriminate, and they do discriminate on the source of income on the basis of that, and they just won't rent to people, even if they have a voucher. So they can't make, a lot of times people can't use that vouchers to get a place. So studies have shown that permanent supportive housing, which means services to deal with mental illness, to deal with drug and alcohol problems, case managers, is effective and cost-effective solution for addressing homelessness. And that is something that is sorely needed for people who've been on the street for many years. They just can't break that cycle. It's just not up here. They need some help. They need case management. You know, that's certainly true for people who have serious mental illnesses. So let me give you a little background of a little bit about myself and how I got into the Martin versus City of Boise case. So I have been advocating on behalf of the homeless men, women, and children in Boise for over 35 years. I just finished my 46th year as an attorney. And when I started, there wasn't even a shelter in Boise. And I got involved and volunteered to assist with the opening of a homeless shelter that was created by a nonprofit in the city as a partnership. The nonprofit actually contributed over $1 million to the construction of the city, and then most of the other money came through federal funding sources. So it wasn't taxpayer sources from the city or even the state. And don't get me started on the state, because the state of Idaho doesn't do anything to address this problem. You know, they're part of the problem, actually, in my view. The city, what happened was in 2005, the city decided they didn't want to deal with the homeless shelter anymore. And they basically took over operations, which was a mistake, of course, because they didn't know how to run a shelter. They took it over from the nonprofit. And then after a couple of years, they realized that it wasn't working out. And so they approached a religious organization that operated 2 shelters, one for men in which they could put sex offenders, registered sex offenders, and one for women and children. And this would even separate families in times of crisis, or where a caregiver person needed to be with the other person. And if you had a male child, 12 or over, you couldn't go to the women's shelter with that child. So I don't know, so they couldn't get the shelter. So they decided to lease this building, 3,200 square feet. Cost like, I don't know, I think a little over $3 million to construct in the early 90s. For $1 a year to the religious shelter to run a men-only shelter. They passed the ordinance that approved the sale, but the religious shelter, it's the rescue mission, didn't want to pay what the appraisal was. And so they just didn't bid on it. They had to have an open seal bid on it. They actually tried to get it to them under the table, and we raised the issue. Well, you know, there's a state statute. You just can't get rid of city property to who you want. You got to have a sealed bid, and you got to have a public hearing and all those things that, you know, city governments usually do before they take action. And so to satisfy the rescue mission, they incorporated a men's only policy in the ordinance saying 66 men only would occupy the shelter. And that's like saying 66 white people. You can't do that. You can't discriminate on the basis of sex, can't discriminate on the basis of religion, can't put on gender, national origin. We all know those areas, right? And blatantly facial discrimination. I mean, it's like a gift for me. I just kind of laughed when I saw that. Like, you know, I don't know where these attorneys went to law school, but you just can't do that in what was it, 2005 or 6, you know? So, but they rented it, and I sued them, and I couldn't get a preliminary injunction. I had appealed to the Ninth Circuit, and who was the Ninth Circuit judge that's still on the bench from here, from Montana? Sid Thomas was on my panel, actually. I think he may have wrote the opinion. Well, in other words, I won, you know, of course. And they said, no, you can't. They not only said you can't, it was discriminatory, facially discriminatory under the Fair Housing Act. They said it violated the First Amendment, which was, that was a good decision, right? But it remanded it back. But the city decided that they would lease it to the rescue mission. And when they leased it, there were people living there, women and children. They just threw them all out, called the cops and threw them out. And so where were these people going to go? Except to public places to sleep. And so all of a sudden we had, you know, they weren't on the sidewalk and they weren't places. The homeless are very good at trying to get out of people's way, you know, and not be seen in small towns. I'm not talking about LA, San Francisco, or Seattle. You know, we have a river. They can go down the river. They can go to parks. They can really hide out. They're good at this, especially the veterans. They're really good, you know. And so it's a little more difficult for women and children, obviously. So they started to do quote unquote sweeps. And I got the emails and all the literature. And the police were making a game of this, counting up how many tickets they could give these people, you know? And so it's a misdemeanor. So what happens? You got to go to court. You get a public defender. First, you're arrested. You know, they'll arrest somebody. Some of them they just cited, and then they have to, you know, show up in court. You got to get a public defender. If you're arrested, you got to spend a weekend in jail. So we have a bed for a homeless person for sleeping instead of a criminal, right? And then they want, you know, $59 billion to build an addition to the jail. This makes no economic sense for the taxpayer or anything else. But in any case, that's what we're dealing with. And we got police officers having to go to court and prosecutors and judges and the whole, everything we're all used to as attorneys. And the judges kind of go, well, what am I going to do to this guy? He doesn't have any money, you know? I could fine him, but he can't pay, you know? And so if you plead guilty, you can go. So or if you didn't show up or you didn't, put in a plea, get arraigned, you know, you get an arrest warrant for failure to appear, and then they pick you up again. I mean, to me, it was insanity. And so I'm like, well, there's got to be something we can do. And so we came up with this Eighth Amendment theory, like you can't criminalize the status of being homeless when they have no alternatives but to be in public places, to sleep, to sit, to lie down. And so we filed the complaint in 2009. It was dismissed the first time out by the district judge, and was dismissed on mootness because the city amended this ordinance to address some of our concerns with the ordinance, existing ordinance. They really didn't even have a definition of camping. And on the Rooker-Feldman doctrine, how many lawyers in town and in here have ever had a case with the Rooker-Feldman doctrine? There you go, one. Oh, two maybe. Well, I had never had a case till then, you know. I kind of remembered it from law school, but I had to look it up, right? Anyway, they reversed on that because it wasn't applicable. Went back to the district judge. He dismissed it again. This time on standing, which is a real problem with homeless people, you know. After so many years, you don't want your homeless people, if they have an opportunity to get an apartment, you don't want them to continue to be homeless. So you got to get new plaintiffs. But we still had some. And the Heck versus Humphrey favorable determination requirement for civil rights cases, which is, again, is another one of those doctrines that the Supreme Court came up with that kind of restrict civil rights cases, any kind of civil rights case. So he dismissed it on those. So we appealed that again. And the Ninth Circuit reversed again, and they issued the decision in Martin versus City of Boise, which said that you cannot criminalize the status of being homeless because sleeping, sitting, lying is a human activity that we all have to do. So they distinguish between the status as a homeless person and conduct. So in other words, you know, if you were trespassing, as I said, or you had an open container, that's conduct. You can write a ticket for that kind of stuff, but you can't write a ticket just for the fact that this person has no alternative shelter. And they also said that there was no right to housing. The city didn't have to provide housing, and you could regulate time, place, manner of how a person would do that. So in other words, you could set between the hours of such and such. You could set not in the middle of a sidewalk, or certainly not in the middle of the street to obstruct traffic. It gave the cities the opportunity to do all those things. And that was a tremendous victory, not only in the Ninth Circuit, because every district court in the Ninth Circuit, which is as we know, the western part of the United States, Hawaii and Alaska, it gave a defense. And in my mind, it focused the localities on the issue. It just don't turn it over to the police and let the courts handle it. You know, and I don't have anything against the police officers. I knew all of them, you know. They knew me, and I'd go down there and talk to them, you know. And I have represented police officers, actually, you know. I've actually also sued police officers, but I'm just a straight shooter. If you do your job, you're fine with me. And if they screw with you, you know, I'll defend you every day. So I think what it did in my mind was force people the local government officials, the city councils, the mayors, even the legislatures in some cases, to deal with this homeless issue, to deal with the affordable housing issue. And in the Martin case, the city appealed to the petition to the Supreme Court with the same law firm out of LA or the national law firm, whatever the hell, I don't remember names like that, Gibson Dunn, right? They petitioned and the Supreme Court denied cert in 2019. So the city settled, we amended the ordinances to incorporate the Martin principles, and we got the city to provide more funding for homeless services, to expand those services, which has improved things. But I think it's really helpful if for the understanding of the homelessness case to talk about the context of Martin and the subsequent case in Grand Pass, which last June overruled the holding under the Eighth Amendment, which I'll get to. But I think for Missoula and for other places, looking at the facts on the ground in Boise and Grand Pass, you guys are somewhere in the middle. I think that helps you understand the issue. So Boise, the city's housing needs analysis in 2021 estimated that the city would need 2,145 affordable housing units to be built each year to meet the existing and future needs of the low-income population. The government requires for localities to receive funding, they require what they call a point-in-time count. Point-in-time count means on a single day in January, no less, you go out and you count how many people are in the shelters and how many people are unsheltered. I used to do this. You never, it's a total undercount. You're never going to find everyone. I mean, you can go to the day shelters. You go to the place where they congregate, libraries, this soup kitchen, health centers, churches, because churches will provide a meal or some coffee or something. And you count, but everyone recognizes it's an undercount. So on a single day, recently, the Boise had 687 unhoused people. Boise has what's referred to as a low barrier shelter. They don't have any really entry requirements. You don't have to be a certain religion. You don't have to be a certain or sexual orientation. They're not going to make you pray to whatever religion they follow. And so they call it low barrier. I don't really like that term, but that's the term of art, I guess. It only has like 150 beds. So as I said, 687. Well, where's everybody else? Well, some of them are couch surfing. Some of them are camped in the foothills. They're around. But you got to know where to look. And Boise has, as I said, one religious provider with 2 shelters that separate the sexes. And they have a length of stay restriction. You can stay 14 days, and then you have to enroll in our religious programs. And that's just a straight Christian program. I don't care that doesn't bother me, but what bothers me is forcing your faith on somebody else and not recognizing them as a person and their faith, or for that matter, no faith. And so people wouldn't go there. So Boise's ordinances, very typical. The camping ordinances, as I said, was a misdemeanor to use any street, sidewalk, park, or public place as a camping place at any time. In other words, there's no place you could be without getting a ticket. And camping was defined as the use of public property as a temporary or permanent place of dwelling, lodging, or residence. Disorderly conduct, and this is what killed me. Martin actually was cited under the disorderly conduct ordinance. He had fallen asleep. He had walked around all night, so he wouldn't get a ticket because he'd been warned, walked around all night and went to the alley behind the day shelter. The day shelters, if you're not familiar, are places that are open during the day when the shelters typically close and send everybody out, where they can get a meal, they can get their mail, they can meet with people, they can get a ride to the hospital or a medical provider, they can get shelter from the weather, food. So they congregate there and they wait for it to open because it's not open 24/7. It's open when the shelters aren't open, which are typically 5 to 7 p.m., 5 p.m. to 7 a.m. And they'll be open for those, to provide those services. He was waiting in the alley to get in, and he was lying down because he'd been walking all night to stay awake, and he fell asleep. Next thing you know, he's kicked. Get up. What are you sleep? What are you doing here? You're camping. Oh no, it's disorderly conduct. Got a ticket for sleeping. I just like, jeez, you know. And actually, he was found not guilty eventually, but that's his story, you know. And so you couldn't sleep. The disorderly conduct banned occupying, lodging, or sleeping in any public building, in any building, structure, or public place, whether public or private. Now Johnson versus City Grand Pass. It's a much smaller community, only 38,000 people. It had an estimated rental vacancy rate of 1%. The wait list for housing choice vouchers, those are the subsidized vouchers, was 2,500 applicants. The same is true in Boise. I think they must cap it because it's 2,500. So those are low-income people wanting to get help with their rent. And they never go through that waiting list. If they're on there for 3 years, they never go through it. So you're just waiting till your number comes up, I guess. Their point in time count had 602 people, almost unhoused people. Clearly the number of unhoused people exceeded the number of available beds because Grand Pass doesn't have a public shelter. They just had a religious shelter that had a limited number of beds. And again, they required attendance at Christian services. And not only that, you had to work, unpaid work. So if you had a job, you couldn't go to the job, you had to work for the shelter to have the privilege of staying there. But it just doesn't work for everybody. And if you can't work, you're out. So Grand Pass's ordinances, I used to think Boise's was bad. Grand Pass ordinances were worse. You couldn't sleep on any public sidewalk, street, or alleyway at any time. Camping on any sidewalk, street, alley, lane, public right-of-way, park, bench, or other publicly owned bridge or viaduct was illegal. It was illegal to camp in any of the city parks. Now, these ordinances resulted in hundreds of dollars in court fines and costs. Johnson had lived, the plaintiff, she was an older lady. She had lived in Grand Pass her entire life and could no longer work because she was disabled. Used all her savings and then ended up in a tent in a park. So they cited her. And if you got more than one of these citations, they had what they called an exclusion order. Sounds medieval to me. In other words, you're just excluded. get out of our town. Even though you live there and grew up there, you're excluded. And if you violated it, then you were subject to criminal prosecution. So they apparently were kind of willing to give you a bed in a jail, but they didn't have an alternative unless it was being incarcerated with real criminals. So let me go back to the legal part of Martin and Grand Pass. So the Ninth Circuit in both Martin and in Grand Pass pretty much applied Martin. And those decisions were based upon a 1962 decision in Robinson versus California, which the Supreme Court said it was unconstitutional to make it a criminal offense for persons who were addicted to narcotics. Not using narcotics, not possessing narcotics, but being addicted. So they said you can't criminalize the status of addiction. And that's what we relied on. We said you can't criminalize being homeless. You can't criminalize somebody who has no other place to go to sleep or lie down because of their homelessness status. The court explained its analysis and said that it criminalized what was involuntarily and inseparable from the status of being homeless because, quote, humans are biologically impelled to rest, whether by sitting, lying, or sleeping, unquote. I don't know how you can argue with that. And as I said, but the city wasn't totally without method to regulate the manner, the place, the time people could be on public property, if they didn't have an alternative shelter. So the Supreme Court last June overruled Martin, said it wasn't a violation of the Eighth Amendment. The Eighth Amendment has nothing to do with it. Public camping ordinances do not criminalize the status of being homeless. So Robinson wasn't implicated. So a person doesn't violate the Grand Pass ordinances, or they have no alternative but to violate those ordinances because they are engaging in an act of illegal camping in a public place with a blanket. That's all they were doing. They violated. There was no way around it. If you didn't have a place, and apparently Grand Pass is kind of out, it's more rural, and they said, well, you can go to the U.S. forest land or whatever, federal land, and camp out there. But many of these people have disabilities. They're receiving medical care. Their support systems there. They get their food there. They go to the bathroom there. Their friends are certainly there. The supportive systems are there. And they don't have transportation, so they can't get back and forth. That's why we call it banishment, exclusion. It occurs to me that maybe it violates the right to travel, but that'll be one of the issues that is going to come up in the near future, I suspect. Now the court observed that questions such as when a shelter is available and cannot be found is not within the Eighth Amendment cruel and unusual punishment clause. Like many of our Bill of Rights, it doesn't say, Second Amendment doesn't say you can have an AR, right? But apparently you can, and any other weapon, under certain interpretations. The 14th Amendment says you're entitled to due process of law. It doesn't lay it out. A hearing, notice, doesn't say any of that. Courts have said that's what it means though, right? So they just said, nope, it doesn't comply, it doesn't involve the cruel and unusual punishment law. I wonder, it seems at least cruel, but it's unusual to punish somebody for sleeping. There's not a single person that I know has ever been really subject to a misdemeanor because they were asleep, you know? I mean, when I went to school, there were a lot of students who I think would be guilty of criminal punishment because they were sleeping, you know, in class, you know, for whatever reason. So the court went on and found the Eighth Amendment does not grant federal judges the power to dictate policy solutions to the complex problem of homelessness and take away this responsibility from the people and the elected officials. Well, I don't think we did that. I don't think Martin did that. Martin clearly was a narrow holding and gave our local municipalities and local officials and people through their right to vote the ability to address this issue. But that's what they said. And they said Martin's involuntary homeless test, where the number of unhoused people exceeded the number of beds, was unworkable and impossible to administer. And I will show you it is not impossible, was not impossible to administer because the cities are doing it, some cities. And I mean, they used they kept on repeating this. It says Martin's paralyzed communities and prevented the implementation of policies to address homelessness within the limits of their resources and other needs. Well, Martin said there's no right to housing. So it left it to the public officials to come up with solutions. And I'm going to talk about that. But it did say that states and counties and cities are free to adopt both protections and limitations on public camping. And it uses an example, the state of Oregon, which has statutorily enacted the Martin principles, I call them, and said you could use the necessity of defense to a criminal complaint. So if you don't have a necessity of defense, to me, if you have to be there and you don't have shelter, it's unavoidable because you got to sleep, right? I don't think they can call an expert. And I know we always come up with experts that will say anything. I don't think you can come up with an expert saying, no, they don't really have to sleep. You know, it doesn't work that way. And so Oregon statute actually, and this is something that I think other states can do, obviously. They passed a law that regulates the act of sleeping, lying, sleeping, and keeping warm outdoors on public property that is open to the public. And not every piece of public property is open to the public. But it must be objectively reasonable as to time, place, manner to persons experience homelessness. That's pretty much a Martin principle. And they created an affirmative defense if the law is objectively not reasonable, which I'm waiting to see how that's going to be translated and applied. I recently read a California appeals court decision that actually applied the affirmative defense of necessity to a citation against an individual. Reasonableness is determined on the totality of circumstances, including the impact on the person experiencing homelessness. And we use that totality test in many different contexts as lawyers. The statute says that a political subdivision may allow overnight camping in vehicles and may impose reasonable restrictions and conditions, such as the maximum number of vehicles. Again, I find that to be reasonable. But it does say if you do that, you've got to provide access to sanitation and trash facilities, which is, again, they complain about the conditions, the garbage, the unhealthful sanitary things, but they don't put a trash can out there. I mean, when you gotta go, you gotta go. If you don't have a facility, you can't get into a shelter. You can't, the day shelter is closed. You know, again, that's a human activity that we do every day. They're no different than us. What I think the Supreme Court, you know, and I don't get to lecture the Supreme Court very often, if at all, did not consider, as I said, sleep is a biological necessity. It's not a crime. If you read the Grant Pass ordinances, the purpose, text, and enforcement targets the status of homelessness, not conduct. The only way a person can comply with those ordinances is to leave their hometown or be criminally prosecuted. That's the Hobsonian choice. And the record, they ignored the record in the district court. The record indicated that the ordinance was passed at a special city council meeting that was called to address the homeless. That's why they passed it. And there was testimony by Deputy Chief of Police saying he had never heard of, never seen, was unaware of anybody but homeless people being ticketed under those ordinances. So we know they were targeted. And the definition, you know, it doesn't apply. The Supreme Court said, well, it's conduct because, you know, if you were a law student and you had no place to go, or you were out for the day and you set up a tent in the park, you know, it would apply to you. Well, actually, if you know, that's the conduct, right? Actually, it never did apply to that in under those circumstances. And it only applied if you used some bedding to keep warm from the weather. That was the definition. And as I said, Grant Pass had no public shelters. So what was the alternative? And as I said, again, the Martin holding was narrow. The cities always had the power to regulate the time, place, and manner of public sleeping. The court did leave open the defense of whether, under the Eighth Amendment, fines serve no remedial purpose or excessive, disproportionate to the offense. That also is considered coverage under the Eighth Amendment and under the Due Process Clause. So this is not an end to it, in my view. So what happened? What happened? What did the city of Boise do after the Martin case, which they settled and amended the ordinances and incorporated the protections? Like you couldn't, if a person had a disability and couldn't access a shelter, which many of them do, especially the mentally ill or people who have pulmonary disease, they can't breathe in it. You know, if you've never been in a shelter, you know, I used to do a lot of prison work. Those dormitories would never be allowed in a jail. Double bunk, 3 feet apart. And the people who talk all through the night, the people who are sick and cough, they don't have great ventilation, never mind air conditioning from the hot weather. And actually had a veteran who couldn't breathe, and he had a pickup with a canopy. He was a mechanic, and he was a veteran in Germany, and he worked as a civilian in Germany, but he had to come back to the States because his mother was ill and he wanted to take care of him. But he ran out of money, and so he ended up homeless. And he was very resourceful, so he put a canopy on his old pickup, and he slept in there, and he got tickets. And they tried to tow his truck away, and kind of run down there and stop it. That's a whole nother story. But I mean, they were just after him. You know, many cities have time limits on parking on the street, like 72 hours. But he had a handicap sticker, you know, and they said it was fake. It wasn't fake. Unbelievable. And I finally got convinced the prosecutors to give him a reasonable accommodation. That I couldn't believe it, what they were doing to this guy. And he actually had cancer. So eventually he got out of his truck and went to the VA hospital and he passed away. So get some more. So getting back to Boise. The city council has approved $5.5 million for a new 95 unit addition to the existing supportive housing unit, which was constructed in 2018 that had 40 units. So this development is specifically for county residents who have been living on the streets for many years. And those are the hardest people to break the cycle and get off the streets. They just have issues. And they need that supportive housing. And as I said, they can get services for their disabilities, they can get case management, they can get help with their medical concerns. The city is also seeking solutions because of the unaffordability of the rents in Boise, you know, like Montana, Idaho is attracting people from all over the country. California, Seattle, Portland. For some reason we're seeing all these Texas plates lately. Apparently Texas is too liberal. I had a guy tell me that the other day. He had to go to a red state. The city entered a public-private homelessness partnership to construct a minimum of 5 affordable housing projects on city-owned land. That makes the ability of private developers to construct housing at a reasonable cost because they don't have to pay for the land. They get a 99 lease and they can construct it. And if the city's the partner, you know, somehow the zoning ordinances and the building codes, you know, they're more open to working with the developer, because those types of zoning and building codes is a barrier to affordable housing, because the developers have to recover their costs. In order to do that, they got to have, the rents have to cover it. So they need some sort of subsidy, tax subsidy or tax credits, or the city is using their land. So the city is constructing new housing units as part of the reconstruction of the downtown fire station. It was on a big lot. That is actually right near the existing homeless shelter, right down the street. So they're going to build there. They're going to redevelop the current affordable housing units that they have, which are these old motels that, you know, were constructed in the 50s or something, and they're single level, and, you know, they're spread out. So you can build on that land and put more units and obviously make them handicap accessible and modern, you know. So they're going to do that. They're going to relocate their maintenance facility and use that land for affordable housing. So there's no one solution, but if you really get together and you think about it, what are our resources? What can we do? Where can we do it? How can we do it? You can do it. You can get people off the street into housing that's affordable. You know, so everyone who's on Social Security, everyone who has a job can pay the rent, because it's not a market rent. And this is really important. The city has committed $8 million to buy 40 new permanent homes for families who are experiencing homelessness. That's the worst. Another program is they assisted 841 families with children with an eviction rental prevention program. In other words, they fell behind in their rent or they had an unexpected bill, and they will help them catch up. They did a lot of this during the pandemic under the CARES Act. That was part of the program. Well, that's not available anymore, but it kept people in their homes while they couldn't go to work. The same Same thing works for homeless people and homeless families. Those typically are having a momentary issue with, could be health, it could be a job, could be they have to take care of a child, you know, things like that. And they don't have, you know, they live paycheck to paycheck. They don't have the flexibility, you know, to continually pay rent. So let me bring this back to you guys, or those of you who live in Missoula. So I looked some of this up to give it context. Missoula has an estimated population of 80,000. It has identified 659 unhoused people as part of the HMS, which is the homeless, they register to get services under the federal requirements for these emergency shelter grants. So they have 659 unhoused people. According to what I saw, they have 315 available shelter beds. So they have a gap, obviously. The vacancy rate here, according to the realtors, I guess, is 4.4%. So there is some vacancy. They had a temporary safe outdoor space in 2023 that served 101 people. Obviously, they were some of those people that didn't have available beds. And they had said that they had constructed 400 units of supported housing and non-market rent units that were added last year. That's all good. All those things are good. And now they've adopted a new camping ordinance in June of this year. So I took a look at that. And, you know, it's a step in the right direction. They are going to allow unhoused people who have vehicles to camp, to park those vehicles and stay in their vehicles for up to 90 days. You got to have a permit. And then you gotta move to a different street, I guess, and you get a new permit. It's like a 30-day permit, but it's renewed, can be renewed up to 90 days. Okay, that works. There are some specific location exemptions, schools, different things like that, that you can't park on that street. And then the city plans to develop 30 clean, safe, and sanitary camping and safe parking sites on city property. Again, that's an improvement. That's going to help. However, this is the one thing that I think is a problem. The city limited camping to between the hours of 8 p.m. at night to 8 a.m. in the morning. I don't see how that's going to work. The people have to remove all their structures and property at 8 a.m. Well, what are they going to do with that? In the wintertime, when does it get dark here? I mean, what are they supposed to do, you know, when it's below zero? What are they supposed to do if it's snowing or raining? Just stand there holding their gear because there's no place, they don't have a place to store it, you know? I don't understand that. That it's either not going to work or they're just going to have problems. So if you know any of those city councilmen, you might register a concern. I mean, it doesn't necessarily work with work schedules. A lot of these people, they work in the restaurant business. They bus tables, they work in the kitchen. They don't get off at 8 p.m. to get a spot. They work sometimes till 11, 12 o'clock at night. Then they got to haul their stuff back. I don't see how that works. And they say they're going to have site monitoring and enforcement process. Well, if they're going to have site monitoring and enforcement, why can't they just stay there? To me, it makes no sense. And so part of the enforcement, because you always have to have enforcement, I guess, for a violation of their time, place, permit requirements, you get a written warning, okay, with suggested remedies. In other words, if you're not keeping your, there's garbage outside your vehicle or something like that, you can't do that. That's fine, perfectly fine. Second violation within 1 year is an infraction, not a criminal charge. Again, an improvement, but I don't think that really stops somebody. If they got to sleep, they got to sleep, you know? And then typically if you don't pay, you get, there's a penalty. And then they have this abatement thing to, what time do I go to? I'm at time? Okay. Well, you can read in the ordinance on abatement. We're supposed to have time for questions, but we started 15 minutes late, so I'm going to leave it to our people here. I'm happy to answer questions either here or later. Colin, what should I do? Later. Okay. Well, I want to thank everybody, but I do want to say one thing, both for the students and the attorneys in the office. You know, we are so privileged to practice law and to go to law school, especially at a state university, because the costs of private universities are crazy. You know, I went to a state university. I wouldn't have been a lawyer. And so I encourage the students to do work like this, pro bono. And I encourage the lawyers in this audience who have firms to allow their young associates to do these cases. They will learn so much. They will be a better attorney. And it's good for your community. And it's good for your soul. Thank you.